Good evening, everyone. Can you all hear me? Good evening. Please, can someone confirm if they can hear me? Please, can I have someone confirm if that they can hear me?
Sure, you are audible.
All right. Thank you very much. Thank you very much, Sophie. Good evening, everyone. Welcome to today's session. We're in the third week of the JIIPCC mentorship and internship program. We've come. I think this is like the midpoints of the program. Well, not exactly the midpoints, but around the midpoint of our mentorship program. And I'm sure coming from the first week and second week down to this third week, we've learned quite a lot. We've had wonderful interactions with our mentors. And with that, I just want to welcome all of us to today's class. You are highly welcome. Thank you for joining in on time. I want to ask that if it's possible for our mentees to go let other let other mentees that class has started in their different subs in your different subgroups, and also on the WhatsApp platform. You can just let other mentees know that the session has started. So welcome once again to our today's session. My name is Dennis Williams, and I will be your moderator for today. Right, our topic for today is arbitration slash career opportunities. I'm sure our mentors will be joining us soon to take us through today's topic on arbitration and what are the career opportunities that are listed in arbitration or that are possible for someone who is enthusiastic about arbitration. With that, we'll just go straight to take today's announcement and then we'll read our mentor's profile. Okay, for our announcements, registration for next quarter, our next batch of mentorship program has officially commenced. So if you have friends who are interested in registering for the gypsy mentorship and internship program, you can share our flyers with them, you can share our links with them, you can reach out to me, and then I'll share the registration link with them. And I trust that they'll be able to register and partake in this wonderful program. I'm sure it's been a wonderful program for you all, as it has been for me. Yes, I know it's been a little bit stressful on both ends for both mentees and mentors, for both mentees and the coordinators, and maybe probably even mentors. But I'm sure that it has been rewarding and it has been worth the while. So please, you would for you to kindly recommend our mentorship program to your friends, to your relatives, to your colleagues, to your schoolmates. We would really appreciate that. So, going straight to our mentor's profile, our first mentor for today is Baratu Johanna Dangana. Baratu Y Dangana is passionate about dispute resolution as well as core legal practice. Her desire to see that disputes are resolved amicably in our society propelled her to enroll and become a certified mediator and arbitrator. Um, as she is a full member of the Settlement House ADR ADR Training Institute, and institutes for training practice and certification in ADR. She is also a full member of the Nigerian Institute of Chartered Arbitrators, an institution that trains and certified arbitrators and mediators in Nigeria, and holds a master's degree in law. She was called to the Nigerian bar in 2007 and currently a senior associate of JB Dauda San and Co. Kaduna, Nigeria. She has expertise in labor-related matters and has successfully published articles such as character evidence in criminal cases. Final project Usman Danfodio University 2006, the role of the National Industrial Court of Prospect the role of the National Industrial Court of Nigeria in resolution of labor disputes in Nigeria, challenges and prospects. Seminal papers presented at LLM Labor Law class in 2017, unfair labor practices and legal effects of termination and dismissal of employees in Nigeria and Ghana. Um, Masters in Law dissertation, University of Jos. 2018. She is also a member of the Nigerian Bar Association, Nigerian Bar Association, International Bar Association, Commonwealth Lawyers Association, and has attended conferences organized by these prestigious bodies where she has gained enormous experience. Thank you so much, Mrs. Baratu, for joining in. We are always happy to have you around. Your knowledge has been impeccable, and your presence has also been fully and felt. Right. Our second mentor for today is Mr. Samuel Orobosa or Sarenre. Mr. Samuel Orobosa Osarenre is a mediator, an arbitrator, a peace advocate, a negotiator, and a distinguished ADR practitioner to the core. He possesses advanced knowledge and understanding in peace and conflict advocacy, community mediation, family mediation, workplace conflict management and resolution, peace building, amongst others. He's a minister of God. He holds a PGD in theology from the Redeemed Redeemed Christian Bible College, a graduate of the Word of Faith Bible Institute in the Living Faith Church, a lover of peace and the youth. Osa Renren is a graduate of banking and finance from the University of Benin. He has passion for advancing the gospel of ADR, which accounted for his willingness to volunteer and facilitate various means of peaceful and amicable dispute resolution. He is the principal consultant at Curis and Associates Consult and the founder of Rehoboth Encounter Prayer Group. He is a certified peace and security consultant, a chartered human resource consultant, a fellow of the Institute of Chartered Mediators and conciliators, a member of the Resolution Specialists of Institutes of Chartered Mediators and Conciliators, ODR panel of neutrals. He is a member of Nigerian Institute of Chartered Arbitrators. He is a faculty member of Settlement House ADR Training Institute and Nigerian Institute of Chartered Arbitrator. He is a fellow Chartered Institute of Human Resource Management. He's a fellow of the Institute of Global Peace and Conflict Management, and a member of the Society for Peace Study and Practice. He is a current member of the Association of Multi-Door Court House Practitioners and the Edo State Multi-Door Court House.
Why do you think food the water?
Osarenren experience cuts across diverse areas of endeavor as he is consulted for Nigerian Youth Service. He has consulted for Nigerian Youth Service Corps and UNICEF as a master trainer in the National Adolescent Reproductive Health HIV and AIDS project through the NYSC, where he had where he too carried out several capacity-based interventions in various NYC camps in Nigeria. He has also consulted with GIZ on strengthening the system of dispute resolution in markets. He has attended several trainings and hosted several seminars and has modern day technology as his toolkit with proficiency in computer usage. He has great passion for capacity building and research and is married to a beautiful wife and blessed with children. Welcome, Mr. Samuel. We are happy to have you with us today again. Thank you, sir, for all you do for us. Our third mentor for today is Mr. Nanchang Namwan. Nanchang Namwan is a lawyer and the principal partner of the law firm N. Nanchang and Co., a law firm based in Kaduna, Nigeria. He is a certified teacher, trainer, facilitator. He is a faculty member and the executive director of the Settlement House ADR Training Institute, an institution that for the training, certification, and practice of alternative dispute resolution. He is also a member as well as a faculty member of the Nigerian Institute of Chartered Arbitrator, a model arbitration certification institute in Nigeria. He is a certified dispute resolution specialist, an international mediation campus trained mediator, an attorney mediator, a certified mediation advocate, an arbitrator, a certified negotiator, an ADR practitioner, a restorative justice practitioner, and a certified emotional intelligence specialist. He is a certified conflict manager, a certified ADR registrar secretary, a holder of Mediator Academy, United Kingdom certificates in commercial mediation, accredited by the Institute of Chartered Arbitrators (UK), a medical law enthusiast and employment of labor law experts. He is an accredited and trained mediator with Accords International, India, and has completed a course to become a Florida Supreme Court certified county mediator in the United States of America. He served as a judge and an expert assessor in many international mediation and negotiation competitions. He has mentored many students and non-students in the theory and practice of ADR. He has keen interest in the application of ADR in the resolution of medical and negligence disputes, workplace disputes, commercial mediation, faith-based disputes, land disputes, family disputes, amongst others. As a dispute resolution specialist, he has handled several disputes which were amicably settled out of court. He is ever willing and ready to volunteer for and contribute to the development and practice of alternative dispute resolution. He is he is a facilitator for the Professional Diploma in Education of Institute of Education, Ahmadu Bello University's area, as well as an external facilitator with the Federal Polytechnic Kaduna. He is married to his wife and blessed with two children. Thank you, Mr. Nanchang. Thank you for always being here. Thank you for making sure that our collaboration with the Settlement House ADR Training Institute has flourished so well in bringing this mentorship program, this alternative dispute mentorship program to our mentees. We thank you, sir, for what you do, and you're welcome to today's session. Our last but not least on our mentors list for today is Mr. Idris Mohammed. Idris Mohammed is a distinguished legal professional with extensive expertise in telecommunication law, ICT law, arbitration, litigation, and corporate law. He holds a fellowship from the Chartered Institute of Arbitrators. He completed his LLB at Ahmadu Bello University and subsequently obtained a postgraduate diploma in computer and communication law from the University of London. He further pursued an LLM in corporate and commercial law from the same institution. Notably, he holds a diploma in international arbitration from the Chartered Institute of Arbitrators, United Kingdom. Idris is the managing partner at Firma Firm, a leading corporate commercial law firm in Kaduna, Nigeria, where he showcases his litigation proficiency in courts appellate courts, state and federal high courts. He is a thought leader in telecommunication law, information technology law, alternative dispute resolution, and technology in arbitration. He has been invited to speak on this topic both locally and internationally. Idris is recognized as for his corporate law acumen, offering companies secretarial service and legal advisory support to telecommunications and ICT companies. He serves as a non executive director at Swap Technology and Telecom PLC. Idris is a dedicated family man who enjoys football, traveling, and sports and Scrabble. You're welcome, Mr. Idris. It's nice having you today for the first time. Thank you for joining us, sir. We look forward to hearing from you as well as our other mentors on what they have for us today as pertaining our topic for today, arbitration slash career opportunities. Um, with this, I would just like to first and foremost welcome Mr. Nachan. He has, for the last 2 weeks, co-moderated these sessions with me, and I would just want to give him the floor to introduce today's session to us before we have our mentee's presentation. You are welcome, sir. You are welcome, Mr. Nachan.
Thank you very much. Thank you. Um, just a minute. Okay. Can you hear me?
Yes, sir, we can hear you, sir, loud and clear.
Oh, that's good. Okay. You're all welcome to this session of the JIIPCC Charity Mentorship in ADR. I'm happy to have you all here. Today we are going to be looking at a very, very important and distinct aspect of the alternative dispute resolution, mentorship. We have considered, we have looked at several aspects that has to do with general overview. We have looked at the aspect that has to do with mediation. Mediation and some career opportunities in mediation. The sessions were actually very, very interactive and very educative, and I believe that both the mentors and the mentees were really um, appreciated the sessions. Today we are going to be looking at career opportunities and arbitration. Arbitration is another distinct, very special aspect of the alternative dispute resolution. And we have with us some of our mentors to take care of this session with us. So may I, on behalf of the mentorship group, welcome especially our mentors. I can see some of them here. And I think today we also have the privilege of having one of a very commendable ADR practitioner and an arbitrator of international repute with us as well. So I believe that the mentees are going to tap from they are going to tap from wealth of knowledge as well. She has she took out time out of her busy schedule to be with us this evening, and let me just introduce her briefly so that the mentees will get to know her. She will also be with us, I think, in the course of this. Her name is Mispa Free Awosun. She's a Cameroonian with various national and international qualifications. She is currently an associate arbitrator and ADR practitioner at ARMS Capital and Associate Limited, presently in Kigali, Rwanda. She is an international arbitrator and mediator as well. She is a member of the Chartered Institute of Arbitrators, London, and she's a member of African Arbitrators Association. She's also part of the Women in ADR and Women in Arbitration. She holds a master's in law in international trade and investment law in Africa since 2017, awarded by the University of Chang, Cameroon, and a bachelor's degree awarded by the University of Yaoundé Toussoua in Cameroon, as far back as 2014. She is also an investment and commercial transaction consultant and expert for the investors and companies in the realization of their corporate social responsibilities as a CSR expert. She is a founder of and CEO of Voice of Cameroonian Women International Organization and the National Coordinator and Legal Advisor for the Cameroonian Youth for Justice and Freedom. Mispa is someone that you would like to listen to. She's presently the manager of Chartered Institute of Arbitrators Rwanda branch. Please, you can join me. Welcome, Ms. Mispa, for sparing time to be with us this evening. Thank you very much, Mispa, for being with us.
Thank you very much, Nata. And good evening to all the mentees and the mentors in the house. I look forward to this very interesting session to learn, unlearn, and relearn. We keep learning every blessed day. So I'm looking forward to hear from my colleagues and also to transmit the knowledge that I love doing in the ADR ecosystem to the mentees.
You're welcome. So, Mr. Dennis,
Yes,
I think you can go ahead. Thank you very much. Yes.
All right. Thank you so much, Mr. Nachan, for helping us introduce our wonderful mentor that's joined in, Miss Mispa. You're welcome on behalf of the whole of JIIPCC and our mentees. You are highly welcome. We look forward to hearing from you and also learning from your wealth of experience and knowledge. We'll be going straight into our mentees presentation. Right. So for our mentees, we would like to quickly have your presentation very fast. Group one, if you are ready, please, we would like to take your presentation right about now. Presentation time is 7 minutes. Please try as much as possible to stick to time so that we can hear from our mentors. So group one, if you're ready, you can go ahead and make your presentation. And group two, please get ready as well.
Okay, so good evening, everyone.
Yes, good evening, goodness.
Yes, good evening. So my name is Goodness, and I'll be taking the presentation on behalf of Group One. Presentation on behalf of Group One. Let me share my screen. Yeah, so that we can see the PowerPoint that we have. Hello, can you hear me?
Yes, we can hear you, goodness. Though your voice is cracking a bit, but we can hear you. Please go ahead and you can start sharing your screen.
Yes, our presentation.
Hello, goodness. Can you hear us?
Yes, I'm going to be sharing my share this slide.
Okay, so is it Goodness or Gloria that is the presenter for Group One?
It's goodness, goodness, Ademolu.
Yes. Yes, I thought I'm having issues with sharing this screen. Could you please help us share?
Okay, just go ahead and start the presentation. I will try and access your presentation and share your screen.
All right. Thank you very much.
Just start. Go ahead and start.
But Goodness, who was supposed to share the screen for you?
No, I'm the one to share the screen. But now
I thought you had
I
someone who shares screen and the person who presents.
So the presenter is the one that is supposed to share screen while presentation, but it seems she's having network issues on my end, so I will just help her share the screen, sir.
All right, go ahead, please.
All right. Thank you, sir. So today we're looking at starting with various career opportunities in ADR. And all right, the screen is up. Thank you. So to begin with, arbitration is a form of dispute resolution, one of the ways in resolving disputes in ADR, where the neutral third party makes binding decision that make a decision that is binding on the parties. And some examples of career opportunities in arbitration are like the arbitrator, which is the neutral third party, which conducts the arbitration hearing and listens to arguments from both sides and issue the award. We also have trainer, ADR coordinator, and then we also have counsel. Counsel, that's advocate, like lawyers that specializes in arbitration that represents parties in a dispute. We also have academic or researcher. This set of people conduct research on arbitration, and they can also teach in universities or in school. They can teach courses on arbitration. Then the next slide, please, going to whether or not the next slide, that's talking about the arbitrability of disputes under arbitration. So examples of disputes that can be, because to start with, it's not all disputes that can be resolved through arbitration. There are certain disputes that are best resolved by the court, and then there are certain disputes that are best resolved through arbitration. So examples of disputes that can be resolved by arbitration, we have commercial disputes. This is one foremost dispute which can be resolved through arbitration. Commercial dispute that occurs between, companies or various organizations, and they don't want their name to be dragged, in the public for negative things, since arbitration offers confidentiality. So commercial dispute is one of the disputes that can be resolved through arbitration. Then we have employment disputes, we have investor disputes, we also have constructional disputes, intellectual property disputes. Then some disputes that cannot be resolved through arbitration that are best resolved through the courts. We have, for instance, disputes like criminal offenses. Those are issues that are best resolved by courts because it's of public interest. So they're best resolved by courts. And also we have family law matters like divorce, child custody, and all of that. And also issues like fundamental right issues and all of that, they are best determined by the courts. Then going to the next slide, please, which is talking about the arbitration clause and its significance. One important thing about arbitration clause and its significance is the fact that in the agreement between parties, the mere fact that they stated that the dispute will be resolved through arbitration, that automatically brings about that matter being resolved through arbitration and not courts. So the fact that it was stated in the agreement, the parties stated it in the agreement that whenever dispute arises, they would resolve it through arbitration. And part of the significance is confidentiality. As we are seeing from the slides, we have efficiency and cost effectiveness. Although arbitration too has its own, it's also expensive and it's a core cost, just like court method. But we also have confidentiality and expertise and specialization. Emphasizing on that expertise and specialization, parties can bring in arbitrators that have diverse knowledge, that have in-depth knowledge about the subject matter in disputes, that is able to give a solid decision, that is able to make a decision based on the wealth of his expertise. So parties can appoint such arbitrator, and also confidentiality. Now going to the next slide as to whether or not the revocation or otherwise of arbitration clause and agreement. So for the revocation of arbitration clause and agreement is not a straightforward answer, in that it can be revoked and it cannot, it might be revoked and might not be revoked. So cases where arbitration clause might be revoked is where parties state it in the agreement on how to go about the revocation. So some arbitration clause provide for how it can be revoked. And that's as seen on the slide number 2, which is through mutual agreement. And also, if both parties on their own decide to revoke it, that's mutual agreement, decide to revoke it, then the arbitration clause can be revoked. Oh, my time is sorry, let me rush today. And cases where it might not be revoked is where the arbitration has already commenced and then is only one party that now wants out. In that case, it may not be revoked. And finally, the arbitral awards and then its components. So arbitral awards are what are issued by the arbitrator as the final decision regarding the dispute in question between parties. And these arbitral awards are similar to court judgments too. The way it's done in traditional courts, in this case, they are arbitral awards. And it has certain components which can be seen in the slides. And also, the components include the name and address of parties, the name of arbitrator, the dispute, and how the arbitrator arrived at their decision, the legal principles and everything they relied on to arrive at their decision. I'm really sorry for exceeding time, but this is the presentation on behalf of Group 1. Thank you.
Thank you very much, Goodness, for helping us run through your presentation. We are really grateful. I would like to say a big sorry for my screen was shaking while I was trying to help display the screen. So thank you very much, Goodness, and well done to all Group 1 members for putting together that wonderful presentation. We say job well done, very, very commendable work. Right, so we'll be taking Group Two's presentation right about now. So Group Two, please, Group Presenter, if you're ready, this floor is yours. You can have your presentation now.
Good evening, everyone.
Yes, good evening.
All right, so I'll be taking the presentation for Group 2. So to begin with, I would like to define arbitration. Arbitration is a form of alternative dispute resolution where a neutral third party or intermediary called an arbitrator hears the dispute from both sides and make a decision. It's more of a way to handle conflict outside of the traditional court system. There are various advantages such as the fast process, it is less formal, cost effective, and highly confidential. So onto its application, it is applicable to a wide range of disputes, often included in contracts from streamlined resolution, which is quick, efficient, and cost arbitral award. Arbitral awards are decisions made by arbitrators.
Amos, are you sharing your screen?
No, sir. I think Mr. James is supposed to do that, right?
Sorry,
Huh?
I'm having a little issue accessing this slide, so I'll start sharing very soon. Sorry, please, you can go ahead with your presentation. I'll start sharing
All
right
right.
about now.
Thank you, sir. All right, so moving on, I'm talking about how to draft an arbitral award. So an arbitral award, in essence, are decisions made by arbitrators in arbitration proceedings. To draft an arbitral award, we'll begin with the title, which is the arbitration award. Then we go to the parties, the names of the parties involved in the arbitration. And then we'll have the arbitrators, which includes the names of the arbitrators involved in the arbitration. Then the case reference, including reference number or any other relevant identifiers. Then we'll go to the background. We'll briefly summarize the background or the context of the disputes in essence, and then the issues, we'll list the main issues presented for the arbitration. And then the findings, we'll give a detail of the findings of the arbitrators on each issues. Then the reasoning, we'll provide the reasoning behind the arbitrator's finding, including the reference, the law, and any other relevant precedents. Then we go on to the decision. We have to, in drafting an arbitral award, the decision has to present the final decision of the arbitrators on each issues, including any award or remedies granted. Then the cost. We also have to specify any cost awarded and the rationales behind the decision. Then the date and signature of the award and the signature of the arbitrators are also very important. So there are key features which involves impartiality, reasoned decisions as award. They provide a detailed explanation of the arbitrator's findings and reasonings. Then we also have final, and the decisions of the arbitrators are final and binding. and it's enforceable. Parties can enforce the award in accordance with applicable laws and conventions. So the arbitration clause, moving on, talking about the arbitration clause, it's more of a provision in contracts that states that any dispute arising from the contract will be resolved through arbitration rather than through litigation in courts. It's relevant because both parties have to, their consent offers mutual consent. It has to be confidential. It offers simplicity and the freedom to choose arbitrators. Moving on, I'm talking about the ethics in arbitration. The ethics in arbitration, it encompasses principles such as impartiality, integrity, fairness, and confidentiality. Arbitrators must maintain impartiality, disclose any conflict of interest, and ensure fair treatment of all parties. Confidentiality is crucial to protect sensitive information disclosed, especially during the arbitration process. Upholding ethical standards would enhance the credibility and the integrity of the arbitration process. So moving on quickly, I would like to talk about the differences between the seats, place, and rules of arbitration. Now, seat in essence means it determines the legal framework governing the arbitration proceedings, including the applicable arbitration laws and courts with supervisory jurisdiction over the arbitration. It does not necessarily indicate the physical location or just physical location. So now the place in essence is of arbitration refers to the physical location where hearings and other procedural steps of arbitration takes place. It may or may not be the same as the seat of arbitration. While we also go on to the rules of arbitration. The rules of arbitration governs our body of rules that govern the procedural aspect of the arbitration, including the appointment of arbitrators, the conduct of hearing, the submission of evidence, and issuance of award. Different arbitration, it is very important to know that different arbitration institutions have their own set of rules governing arbitration proceedings. Also, we're talking about the challenges on arbitral award. There are conditions for challenging an arbitral award, many varying depending on the applicable laws and arbitration rules. So, but there are common grounds for challenging arbitral awards, which include lack of jurisdiction, procedural irregularities, breach of natural justice, public policy violation, error in law or fact. Now, challenges are typically brought before the court or the seat of the arbitrator within a specific time frame following the issuance of the award. Moving on, finally, I would want to talk about the enforceability of arbitral award. Arbitral awards are generally enforceable, both domestically and internationally under the New York Convention. The recognition and enforcement of foreign arbitral award. To enforce an arbitral award, parties must file an application in a competent court where enforcement is sought. The court will review the award, then if satisfied rather, they will grant enforcement in accordance with the applicable legal procedures. Arbitral award benefits from a strong presumption of enforceability, subject to limited grounds for refusal, as outlined in the New York Convention International Arbitration Laws. In conclusion, arbitration is very essential as it over time has proven to be used more often, both in the world today. Like, it's something that its relevance has increased generally, as many companies, many firms, many persons prefer to go through these procedures, especially because of the timeliness, the time, the confidentiality most especially. I think that'll be all. Thank you very much. That'll be all for Group 2 presentation.
Thank you so much, Phoebe, for that presentation. Right, you were very fluent and very easy to understand. Though I kind of found it difficult knowing exactly from which part of the slide you were picking from or you were talking from. But still, yet very commendable efforts from you and your group members. Well done to everyone who put in their collective efforts to make sure that Group 2 was able to make their presentation. So now we'll be going back to hear from our mentors as they give us an overview of today's topic, and not just an overview, they also comment on the presentation that was made by our groups, our mentees. So we would like to give the floor back to Mr. Namwan, right, so that he can help us give us a run through and also assign our mentors with the different aspects of arbitration they will be leading us to talk about today. You're welcome back, sir, Mr. Nachan.
Thank you very much. I thought we were going to take the photograph before we start commenting.
Oh, okay, yes. Sorry about that. It's totally skipped my mind. Please, we would like for our mentees to turn on their video cameras so that we can take our quick photograph before the weather becomes, or the lighting in our backgrounds become very dark. So please, if you can, we'd just like to have our mentees turn on their video cameras so that we can take a quick screen. All right, thank you very much. I'm done with the pictures. Mr. Nancham, over to you, sir.
Okay. So, thank you. Thank you very much, Dennis, for that wonderful session and the coordination. And so we are going to go to the next session, the comments, the overview by the mentees, and then please take notes and write down your questions where necessary, and be certain that your questions will be attended to. So, Mr. Idris. Mr. Idris with us.
Yes, Nanchang, I'm here. I'm here with you. I'm here with you, Nanchang.
Okay, sir.
Hello.
We've sent you the. Yes. Yeah. Can you hear me?
Yes, I can hear you very well, Nanchang. Thank you so much for having me here.
All right. So you saw some of the things presented by Group 1 and Group 2, and then you also are privy to some of the things they are expected to cover up in the course of their research and putting their slides together. So at this point, we would like to welcome your comments generally on some of the things that are expected, inclusive of what they have presented, please.
Okay, thank you so much to Nanchang of the Shati and the JIIPC for this invitation. I'm highly honored to be here with you. First of all, let me commend the mentees for the brilliant work they have
Please,
done.
I don't know whether you can have your camera on, please. Is it convenient?
Okay, but you have to give me like 2 minutes for me to set it up.
Okay.
My battery is kind of low. I'm out of town. So I would switch it on, but you just have to give me like 2 minutes for me to get it on and to set it up.
That's good. Thank you.
Okay.
We will appreciate that. Yes.
All right, just give me 2 minutes and I'll get back on.
Yeah, thank you very much. Yes. So well, Mr. Idris is setting up. We would like to be seeing his face in the course of the conversation where possible. And so that's why I made that request. Dennis, I hope that is okay.
That's fine, sir.
Okay, thank you. So, Baratu, are you with us?
Okay,
Yes,
I think I
Mr.
can set
Lanchan,
up with
good
you now,
evening.
and I'm fine. And
Okay, that's good. All right, please go ahead.
okay, I think you can see me now, right?
Yeah, very well. Thank you, sir.
Okay then. All right. So I was commending both groups for a very brilliant presentation. It was obvious that a lot of efforts were put into it. I will intercede more from a practical point of view, and my intercession would essentially be to beef up on some of the presentations and to also give you some practical aspects of arbitration itself. Now, first things first. Again, I must tell you, you all did a brilliant job. But let's look at it from another perspective. And this is a perspective that what do you meet in practice? I mean, okay, I have an arbitration dispute. I want to commence that arbitration dispute. What do I need to do? Or I want to make arbitration my dispute resolution option. If a dispute arises in any commercial transaction, what do I need to do? So I'll take those first two questions and I will align it with some of the presentations that have already been made. The first things first, I think it was in the slide number 2 or 3 of the first that stated that how do you, examples of disputes resolved that can be resolved using arbitration. One very critical fact, and in fact, when you go for most of the trainings with any of the institutes that they always tell you, is that all arbitrations are party-driven. And what does this mean? That unlike a situation like in the normal courts where as soon as a dispute arises, you rush to the courts to file your papers, before the disputers are arisen, most times, I did not say all the time, before the disputers are arisen, there must be a dispute, an arbitration clause in an agreement or an arbitration agreement. This arbitration agreement is what confers the jurisdiction on any panel that or tribunal that is set up as a consequence of the application of that arbitration agreement. So I'm taking it from the process of how do I commence? How do I use arbitration as a dispute resolution mechanism? So you must have the arbitration clause or arbitration agreement within the overall picture of the agreement itself. So the second issue that I'll quickly go into is what is the nature of an arbitration clause? And I think in most of the slides, some of the slides, there had been an attempt to tackle this, but with just a little guideline, the arbitration clause must confer directly that this dispute is to be resolved where any conflict or so and so on as a reason from the interpretation or the operation of the agreement itself, that there must be a reference to arbitration. And the word arbitration should clearly be used and stated in the arbitration clause. There are so many other things which you have already stated: the seat of the arbitration, the mode of appointment of the arbitrator, where the mode fails, what are the recalls. There's so many other things that should be contained in a very good arbitration clause, which I think was dealt with, especially I think with the second slide. So having dealt with that, I would like to talk on on a very particular thing, and this has to do with the first slide that was presented by the first group, career opportunities in arbitration. And this is more or less to encourage all of you to consider a career, particularly in arbitration. I would like to use a personal story. I did my master's outside the country, and part of the modules I took was arbitration courses. Were arbitration courses. So at the end of it, I really wanted to know what I could do with it. I now found out that the Institute of Chartered Arbitrators, United Kingdom, could give me a direct membership because I took those courses within my university. And that's how I became an arbitrator. The story I'm trying to tell here is my very first brief. And what did I do as soon as I finished? I already had an established line of clients, particularly in the telecoms industry in Nigeria. I already was practicing more in the litigation and commercial and corporate law space. So I just informed most of my clients, hey, look, I'm qualified as an arbitrator now. And you not believe it, that the very first opportunity I had to act as a counsel on behalf of a particular company, we're able to secure an award in millions of dollars, although the company on the other side went bankrupt. I was already dreaming of becoming a super rich man. So the career opportunities in arbitration are enormous. And the more practitioners that you have in it, the more the people, they may want to adopt it. And I'll tell you the reason why I'm saying this. I'm presently involved. I was appointed to act as an arbitrator by the Kaduna Multi-Door Courthouse, right? And the very first meeting we had, in our preliminary meeting, I could see that one of the parties was not too comfortable with the arbitration. And it was apparent that he had never been involved in one. And I tried as much as I could to calm him down, to explain the process to him, to also tell him that it is just, there's nothing that is hidden here. It is a dispute resolution process. However, he took part in the preliminary meeting. We reached long reach of the decisions in the preliminary meeting. I'll tell you after this what the preliminary meeting is all about. And at the end of it all, after finishing the preliminary meeting, we sent minutes of the preliminary meeting to them, and I issued the procedural order. And just like that, he wrote a letter and said that he was no longer, and this is where his direct words, that he was no longer interested. I can talk about this. I'm not breaching any form of confidentiality. You do not know the parties. So I'm just using it as an example for training purposes. So he wrote a letter and said he was no longer interested in the arbitration. Well, that brings me to the next thing that I was about to say. How do you, and I think the third slide by the group one also dealt with this issue, is an arbitration clause revocable? That means, can you resile from an arbitration clause? And the simple answer to that, if I may give you, is that except under the circumstances that she clearly stated in that slide, it is not possible. And for this, as an authority, I am relying on, and one of the things I noticed before I make this submission is that, okay, maybe there were not enough time. There was not enough references to the applicable laws or examples of the applicable laws, especially within our jurisdiction. So interestingly, in Nigeria, we have had the Arbitration and Conciliation Act enacted in 2004 in operation since then. But last year, the Arbitration and Mediation Act was signed into law to 2023, and it really helped to provide further clarity as to the things that we can do under arbitration. In fact, I'm just looking for the particular section now. I think it's section 3. And it states that unless the parties agree otherwise, an arbitration agreement is irrevocable. So once you submit to arbitration, except the parties that initially agreed to get into the arbitration say, okay, we're no longer interested in this arbitration, that arbitration agreement is irrevocable. Now to go back to the process, I mentioned repeatedly the talk of preliminary meeting. So having incited a preliminary an arbitration clause in your agreement, a dispute arises, what do you do as counsel? Now, first things first is to notify, depending, there's so many things, depending on the agreement of parties, depending on so many other variables that the parties must have previously agreed before the dispute arises, then you can now initiate the process. Now, the initiation of the process, again, is based on the parties. If the parties, you could have two, one mediator, one arbitrator, or three. The standard default in most, even in the AMA, is that you could have one, the sole arbitrator, because of the issues of costing and all of that. Now, how do you appoint an arbitrator? Again, it goes back to the parties. The procedure for appointment is a direct corollary as to what the parties have agreed. Usually, it's just for you to notify the other party and suggest a name. And where that name fails, there's an entire procedure under the Arbitration and Mediation Act that you could, the default position under the Arbitration and Mediation Act is application to the Chief Judge of the Federal High Court. That is where the agreement does not state what happens if the appointment procedure fails. Now, let's say, for instance, the entire thing now has been come together, an arbitral tribunal has been constituted, whether it is one or two, or whether it's one or three. Those are the two major ways by which you could appoint, is either one or three, basically. Once that has been constituted, the first thing that the arbitration or the arbitral tribunal would definitely do is to call for a preliminary meeting. What the agenda of a preliminary meeting is just like a pretrial conference, which is to set the guidelines as to the rules and how the arbitration will go. It is a very important meeting because it sets the groundwork and the foundation for the entire arbitration process. So once you have that, you now determine whether you're going to list it, whether you're going to use pleadings, whether you're going to just use documents upfront, what that you need to do in that particular setting. It is the preliminary meeting that also states when the hearing will take place, how the hearing will take place, and it is usually not even, it is more of a meeting. In fact, in those meetings, the arbitrator sits as being a part of the meeting and only acts as guidance. Most of the decisions on the preliminary meeting are taken by the parties. So for instance, if pleadings, do you want to exchange pleadings? That's how the arbitrator would throw the question to the parties. Do you want to exchange pleadings? Yes. If the other one says no, you can ask them why, and you find a way of bringing them to reach an agreement. At the end of that, the minutes are prepared and the procedural order based on what was agreed upon by the parties is also issued. Then you now go for the hearing. Again, parties rule. If the parties decide that, hey, look, we don't want the Evidence Act, perhaps in Nigeria, to be applicable. Or, for instance, you now state that, and which was mentioned, I think, in the second presentation, the place, the seat, and yes, the place and the seats, basically. The seat determines, as rightly pointed out in that presentation, the applicable law, the rules, and all of that. Attached to all arbitration laws, whether it is the ancestral model law, AMA, or any other law, is always the rules of procedure for that arbitration. And also, in most of the arbitral institutes, they always have their laws and the rules guiding them. So you go through that. Again, it's the parties that are involved in it. You also go through, you can also decide if you want written addresses, your closing arguments. And if you don't want that, you can let it go. Domestic arbitration to the larger extent is also different, a lot from international. International has its own peculiar nature, its peculiar wordings, its peculiar mode of presentation. Basically, after that, if parties have agreed to closing arguments, they take it. If parties have not agreed, it is now closed, shut down for the award. Again, both slides, I think more particularly the second slide, did an extensive job on the attributes of a good award. In training to become a fellow, it's a must pass. In fact, the pass mark for that particular model under the Chartered Institute of Arbitrators UK is 70%. I mean, and you write an award based on what you have been taught. The categories of how you write an award is repeatedly drummed into you, and if you miss it out, then you must get that 70%. If not, you probably you'll do a receipt. So after the award, yes, enforceability. The second slide made mention of the New York Convention on enforcement of arbitral judgments. So a little history on that. Countries came together sometime in 1958 as a recognition of the intertwine of international trade. I might be in Nigeria, I'm having a discussion with somebody in New York, America, and a dispute arises. Which court would have jurisdiction? Those things were recurring. So the New York Convention on the Enforcement of Arbitral Judgment. There were so many other international conventions, which I may not want to go into now since we've gotten up to the stage of enforcement, came together, and some couple of nations came together. And basically what they just said was, okay, since we are signatories to this award, and once this New York Convention has been adopted as the local laws, if I get an arbitral award in another country, and that country is a signatory from Nigeria, that country is a signatory, or Nigeria is a signatory to the New York Convention, I can take that award from London, America, anywhere, and come and enforce it in Nigeria. The procedure also is clearly stated. Due to the issues of time, I might not be able to go there. Locally, the Arbitration and Mediation Act also deals with how the enforcement of arbitration awards can be done. And it is basically, as stated, I think, also in slide 2, to file an application before the relevant courts has prescribed by the Arbitration and Mediation Act. Yes, and it was also clearly stated in the slides, which I must commend you guys for doing a very good job, that it's basically by an application. The mode of that application has been hugely controversial in conflicting decisions of the court. So, but it is usually by an application. One of the issues has always been whether do I do it ex parte or do I put the other party on notice? And it is also because you put the other party on notice, that's when you would now wake up and might want to create a challenge against the award. And also, yes, arbitration awards are not basically challengeable. AMA has reduced the lines upon which you can appeal, if I may use that word, an arbitral award, they are limited lines. And the AMA, corrects me if I'm wrong, has also introduced another layer to it by creating what is known as an appeal tribunal within its steps. So having done all of that, I must commend all the presentations that I've done. I've not tried to look at it because I could see that the presentations were looking at arbitration as a mode of resolving disputes. So that's why I've just taken you on a journey from the beginning. There's so many other things that I may have left out, so many other things, but I've just taken you on a journey from a practical journey to look at it from initiation, from the point of inserting an arbitral agreement into the clause to the end of the dispute resolution. There are so many other things that this webinar might not be able to. But again, one very important point I must make is that Because you have constituted an arbitral panel doesn't necessarily mean that there are nothing that the courts of law can do. AMA clearly states that the courts can have interventions on issues of on certain issues. Those are include like what we've just mentioned, the enforcement. You can also go to the courts for the appointment of an arbitrator where the appointment procedure fails. You can also go to court for an interim measure, maybe to restrain a particular party from doing something upon the constitution of the arbitral panel. I'll be back in a couple of minutes, and I'll be glad to treat your questions. But for now, I hope I've been able to at least inspire your thoughts into having an arbitration career. Thank you so much again for having me.
Okay, thank you very much, sir. We are really excited to have you. Please, you need to you can go and do the needful. We'll be expecting you back. Thank you for sparing your time to talk to us. Now, Mr. Idris has laid the foundation, has commented even to the end of what an arbitration process should look like. You just need to remember that whether or not you have an arbitral clause in your agreement, you can actually explore arbitration. But what is advisable is that we often suggest that parties include this arbitral clause in their agreement before a dispute arise. Because where dispute arise is actually difficult for parties to some extent to come together and decide the way and means through which they want to resolve their dispute. So that's why it's advisable to have it beforehand, because we've learned initially that conflicts are inevitable, whether we plan it or not, whether we want it or not, these things happen. So this is something that we need to take note of. Don't prevent it as much as possible, but have a way through which you can resolve it ahead of time. Don't wait until the dispute arose. So thank you very much for that. Ms. Pa, are you with us?
I'm right here.
All right, great. So you have listened to the conversation led by Mr. Idris, the fellow of the Institute, and we are very happy to tap from his knowledge. Now, quickly to you, before other engagements begin to draw your attention. You've seen the slides, you've seen the presentations, you've seen aspects. Please, maybe I would like you to touch on some aspects that Mr. Idris has not touched. You have the outline as to what is going to be discussed by the group 1 and group 2. So please, you can touch on areas that you feel you need to, the mentees need to get some basic knowledge and understanding. Please, over to you.
Okay, thank you very much, Nachang. I mean, I am so elated to be doing this presentation or this discussion. At times, I like mentorship to be more of a discussion, such that we learn, because these thought leaderships are the best type of leadership that I appreciate out there to actually learn practical things. Let me take this opportunity to appreciate all the mentees for doing a wonderful presentation. I ran through all your slides and I also followed up with your presentation. These are opportunities. What this settlement house is doing, they are opportunities that when some of us started, we did not have. If we He practically just touched arbitration from beginning to the end. But I would like to talk about the pathology of the arbitration clause. That is something recently, as the manager of Chartered Institute of Arbitrators, Rwanda branch, I received the Hamburg Chamber of Commerce, where we're entering into a collaboration on cross-border disputes settlement in Africa. And one of our key areas of concern was arbitration clauses. Now we are getting more interested in the arbitration clauses in the banking sectors, in the insurance sectors, and who are the drafters of the contracts under all these sectors? The lawyers. The lawyers are the ones who draft all these clauses. And the clause itself would determine the commitment, the voluntariness of the parties sorting ADR or arbitration, particularly as a mechanism to resolve their dispute. Yeah, there have been some current trends saying that arbitration is costly and so, but I can tell you it is more time saving and it is cheaper. Because when we say it is cheaper, some people say, oh, the amount for fee cost and so on and so forth is very heavy. And so it's time saving because a business, arbitration is mostly for businesses, companies, business entities, investment state. And so when you look at the time, you have to rush through the corridors of the court in litigation. And so you discover some cases in the court, especially in our courts like, for example, Nigeria, Cameroon, and so there are cases that run in the court for years, okay? But presently in Rwanda, where I am, they have the arbitration or ADR policy is that which is trying to decongest the dockets of the courts, of the judges. Docket is the case load, the case file. I will pray you, mentees, to take down notes, some terminologies that I might use, because you know, as a professional, you sometimes speak with the professional terminologies. But as a mentee, you might not know. So I beseech you to take them down and do your research. That's how some of us learned. That's why I say thought leadership is very good. So I'm talking about cost in arbitration. That goes along with slide group 2's presentation on ethical considerations in arbitration. The cost in arbitration can be a ground for denial of the enforcement or the enforcement of an arbitral award, either under the law, the act, or under the treaties or the convention like the New York Convention 1958. So cost has to be very moderate. It has to be justified, because costs that are unjustifiable, a party can raise a suit in court for the revocation. But when you as an arbitrator, you people are future arbitrators coming, you have to ensure that you want to, either you are fixing the nominal fees, there are different types of fees or cost in arbitration. Whether it is nominal, it is fixed, it is hourly, you have to make sure that your cost is according to either the rules, the arbitration rules that you have adopted, either the institutional rules. If it is ad hoc, even if it's ad hoc arbitration, they can also adopt the rules of an institution. For example, you have, like, for example, the Kigali International Arbitration Center, the rules. You have the Chartered Institute of Arbitrators, we have our rules. You have the ICC rules. You have the International Bar, the IBA, that's International Bar Association rules, which those ones are actually soft laws to arbitration. Okay, so you have to make sure that the costs in arbitration is justifiable, because unjustified costs are grounds to set aside your award. And no arbitrator will want to sit on a proceedings and then the national court, when it comes for enforcement, that award is being set aside. So that is something that we have to make sure we take into serious consideration. So let me tell you about the merits of arbitration, which goes with the it goes with the relevance of the arbitration clause. It determines lawyers, they take unnecessary adjournments. That is not the case in arbitration. Unnecessary adjournments are not allowed in arbitration. You have to avoid them by all costs, because if you do so, party might sought recourse in the national court, where they had adopted the law of the seat. Our colleague said something about the law of the seat as it is on your presentation. So many people confuse between the seat and the place of arbitration. The seat, it is the procedural law that determines the proceedings. That is to say that during that arbitration, if you want to take interlocutories, or say you want a kind of a preliminary measure from the court, might be this arbitration, it is in a commercial transaction where it concerns commodities. For example, tomatoes, these perishable commodities. And maybe before the end of that arbitration, the commodity in question or the object in dispute might have perished or have encountered a prejudice. You can sought for a preliminary measure or an interlocutory in the court of the seat. That is the importance of the seat. And when choosing a seat, there are key things you have to look at. Is that seat arbitration friendly? There are still so many courts in Africa today that are not arbitration friendly. Like even in my country, arbitration, ADR generally is not very friendly in my country. So the court might just deliberately not entertain your claim or your request or your appeal because they are not arbitration friendly. They are not ADR friendly. And it's because why? The capacity is not there. Okay? So make sure that you avoid all forms of undue delay in arbitration. And when you respect the terms, you will see that you have little or less court interventions. Because when we say arbitration is a party-driven mechanism of resolving disputes, we have to do everything to make sure that court intervention is very, very less, very minimal. Court intervention should either be when you might need some interventions like interlocutory applications you want to make, or the tribunal wants the court to issue an injunction. An injunction is a kind of application that you demand from the court to actually do what? Suspend or give a command for something to be done within the proceedings. So you can use the court of the sea or the law of the sea in those regards, but you have to make little interventions of the court. That is why it is private. Otherwise, they would have gone for litigation. There is also the lawyer's concept about the litigation spirit. Lawyers are forgetting to understand that when they include arbitral clauses, the standard arbitration clauses, into their become the counsel. Remember, you talk about the opportunities. Either you are an arbitrator, you are a co-arbitrator, or you are a registrar, or you are a tribunal secretary, or you are an expert witness, or you are a counsel to that arbitration. Okay, so those are the career opportunities in arbitration. And lawyers are still finding it challenging, but thank God, due to the awareness of today, lawyers are beginning to embrace ADR gradually because they feel that we are taking the market away from them. But it is a career opportunity for everybody. Lawyers, if you encourage or counsel your parties to include the standard arbitration clauses in their contracts, whether it is banking transaction, it is real estate, it is insurance, it is accommodation, that is like, for example, transport facilities, no matter the type of commercial transaction, get a standard arbitration clause into your contract. And standard arbitration clauses have the pathology, what we call the pathology of arbitration clauses. It has its features. If the features are not there, then that clause lacks its pathology. It must carry the intent calling for the arbitration. That is, for example, any dispute resolving thereof out of this contract shall be resolved by the parties through either arbitration, mediation, conciliation, or negotiation, or adjudication. Then you bring in the seat. You might choose the seat, which is the law of the place where the arbitration is sitting. You bring in the place of the arbitration. Place is physical, is geographic, okay? Place is physical, is geographic. Arbitration can even take place in a plane, in a private jet. That is the thing about difference between place and seat. When we talk about place, we are talking about the physical location, the physical geography. But when we are talking about the seat is the law of the proceedings, the law of the place. And at times, where parties do not choose the seat of the arbitration, sometimes the law of the contract can be adopted as the law of the seat. So remember that you also have to make sure that the law of the seat be arbitration friendly. The law of the seat is that which can safeguard the interests of the intended claim in arbitration. Then let's look at the ethical considerations. In slide 2, they spoke about ethical considerations. They are ethical considerations. For example, I have spoken about unjustified costs. That's one. 2, unjustified delay, which can lead to the attack of the arbitral award. 3, you have to be a good time manager as an arbitrator or even as an arbitral secretary tribunal. Because in drafting the terms of reference in that arbitration as a secretary to the tribunal or the registrar, you have to do it within the required time frame. The other one, again, make sure that you do adequate disclosures. Declare your interest in case there's any conflict of interest. Might be you had been a counsel to that matter when it was in litigation. You would definitely not be a good arbitrator to sit and arbitrate that matter. So you have to declare your conflict of interest. You have to respect the rules of neutrality and impartiality and independence. Independence, the difference between independence and impartiality. Independence goes with especially external influences, either political, social, or economic. There was a time we had a discussion about independence of a tribunal or independence of an arbitrator, especially in ad hoc arbitrations. Might be you are my friend, or I am a community leader, and then you bring me a gift. You bring me a gift during my mom's burial. And now there is a matter that concerns you, and I have to sit on that matter as the arbitrator. What do I do as an arbitrator? Should I declare my interest? Should I declare conflict of interest or what? So the extent to which the gift or the engagement between the arbitrator and the party in concern also matters in the determination of your independence. You have to make sure that whatsoever interest you have will not influence the outcome of the arbitral award. So that is where conflict of interest is very, very important. For the meantime, let me allow these ethical considerations and wrap up with the last part, building your career in arbitration. That was under slide group 1. In building your career in arbitration, there are a lot of opportunities. I'm telling you, there are things you have to do. Some of us, we have done it and we are still doing it today. For example, the first thing you have to do, arbitration as a career path. You have to make sure that you do what? You differentiate arbitration as a career path differently from our ordinary profession. For example, lawyer or banker or accountant or a quantity surveyor or a community leader. You have to differentiate arbitration practice or career from your current career that you might be running. The second one is that arbitration it has a kind of a form of adjudicatoriness in it. So whether you are a lawyer or not, you just need to learn the skills to be a competent arbitrator. It matters. You cannot sell in this business if you don't know how to be a competent arbitrator, how to join facts, law, which is the law of the seat, and your conscience to be able to decipher what is the claim all about and what can be the recourse in this claim. And then the second one, you have to know that due process is a key in arbitration career. You have to follow the principles of fair hearing. That is to say, there's something very important in arbitration, the same like in mediation. If you give me party A, there might be the claimants, you give me 10 minutes to make my claim or to state my claim, you have to give the respondent 10 minutes to state his or her claim as well. Pleadings have to be pleaded with the same timing. If not, your award can be set aside. Your award can be contested before the court of law. Then, remember the second one is that you are different. There are actually different layers of arbitration. Arbitration is different from maybe lawyer's profession or banker's profession or accountant's profession or quantity surveyor's profession. With arbitration, it has different layers. For example, the institution in which I serve, and like so many other institutions, has different layers. For example, the Chartered Institute of Arbitrators, where so many of us here are already members, it has 4 levels. So you need to look for a body, an institution that gives membership and take their exam or their training, obtain their membership, and then you become a professional in that society of arbitrators. Chartered Institute of Arbitrators have 4 levels of membership. You have the ACAB, which is Associate Chartered Arbitrator. You have the MCAB, which is Member Arbitrator. You have the FCAB, which is the Fellow Arbitrator. You have the CAB, which is the Chartered Arbitrator. That is the last stage. Presently, I am an MCAB, that's a member, and I am working towards my fellowship before the end of this year. So, and changes that happens around the ecosystem of arbitration. You must join a professional body. If you don't join a professional body, I tell you the truth, from experience, you cannot excel in this profession because it is the profession that the claims are huge amounts of money. Claims are huge amount of money, so it needs natural. Is Nachan saying something, JIIPCC?
I think he's trying to say something, but it seems he's having
His
network
network.
issue. Yes, ma'am. But you can
Okay.
go ahead. You can continue, ma'am.
Okay. So the third step for you to take arbitration as career path is to start off your arbitration career as a young member. And as a young member, you can be a secretary to a tribunal, you can be a registrar to the tribunal, you can be an expert witness to a tribunal, you can be an observer to a tribunal. You will not stay in your home and have these opportunities. You must do what? You must network. You must attend conferences. You must engage. Okay? You must engage. You must volunteer. Okay? You must do it to develop your future as a leader in arbitration. You must go through these stages. Some people are privileged to be in some law firms that have heavy and quite number of cases. They sail through. But you who don't have, my sister, my brother, you have to go through that career path, okay? Then the 4th criteria I have to give you is building your brand. You have to build your brand. Nachang has built his brand. Idris has built his brand. My other colleagues have built their brand. I have built my brand. And how do you build your brand? You have to practice. Your practice is your brand. Okay? Your practice is your brand. That is to say, all the ethical consideration, what you do as an arbitrator is your brand you are building. If you go and you miss the ethical considerations, you give a useless award that does not have consideration or standards, and that award is set aside. I'm telling you, you are destroying your brand. You have to make sure that the grounds, even it should at least the least one should be under circumstances of public policy that your award can be set aside, because it is a private matter. So take your time, study the case, study the claim, make research, reference, ask even from senior colleagues to make sure that your award is not contested and you have a very perfect and uncontested award that cannot be set aside by any court. Okay? So, who do you write your award for? I ask you this question. You have to answer this question. Who do you write your award for? Under building your brand. Your award must reflect international status or international standards. Your award, because might be because it is a domestic arbitration, it has to reflect international standards. Because if the award is picked and read in America, in Brussels, in Paris, in Hong Kong, it should meet the standards. That is the challenge most African arbitrators they face, because the awards don't meet international standards. And it's not by magic. It is by continuous training and retraining, consultation from senior experts, reading awards from senior experts. Presently, as we speak, for example, like the Hamburg Chamber of Arbitrators, they have now said that they want to start publishing arbitral awards such that it can set itself as a jurisprudence for young arbitrators to pick up awards and read, because normally awards are not published because they're considered private. For example, you here as a Nigerian, have you read the award from the Nigeria versus P&ID case? If you have not read it, please, after this webinar, go and get it, read it. Those are opportunities because they even made that award public for experts to read, okay? So make sure that you avoid your award being set aside. The last one is networking sessions, which is what the settlement house is doing right now. Right now, I am here. My other colleagues are on this platform. You can also do what? Network through.
Okay. Can you hear me?
Question or make a contribution and meaningful contributions. Okay.
All right. Thank you very much.
The case is called Nigeria versus P&ID. So, dear mentees and fellow colleagues, thank you people so much. I took a little bit of time, but sorry about that. I just needed to give you out these very important points. I wish you all good luck
the name of
and
the
the
case,
best
or you
as
can
you
drop it. Miss Pa, you can drop the name of the case on the chat box.
All right.
All right. Thank you very much, Miss Pa. Baratu, are you here?
Yes, I'm here, Mr. Nangchan.
Okay. Can we have your thoughts on any of the aspects that you wish to talk about?
Yes, actually, most of the aspects I will talk about have also been talked about, which is covering the topic, as it were, for both Group 1 and Group 2. But I just want to say that the reason why every one of the mentors seem to be talking about these topics is because of their importance in arbitration. For instance, the topic that has to do with arbitration agreement or arbitration clauses. Arbitration usually swims with those clauses, or it also will come out with those clauses. So if the arbitration agreement is not well drafted, it affects the outcome of the arbitration, and it usually will be a ground for setting aside the arbitration. There are key components of what should be in an arbitration clause, which either as a counsel or as a professional arbitrator, whichever one you want to be in your career, you should be mindful of them in any draft of an arbitration. Already the mentors have stated them, but I just want to repeat them because they are very, very important. And if somebody's, if an arbitration agreement...
Can we see your beautiful face?
Where I am is actually very dark, so you can see it's
No,
not
it's
very
okay. It's
lighted.
okay like that. It's okay.
All right.
We want to see you like this. And you
All
are
right.
looking
So,
beautiful anyway.
well, thanks for the compliment, Mr. Nanshan. So what I was saying is that arbitration clauses are very important for arbitration itself, because if the clause is badly drafted, then the arbitration will be affected at the end of it. So for those of us who are in-house, either as a worker in employment of any organization, we can be of great assistance if in drafting the arbitration clauses, we make sure that they are well drafted. It makes the arbitration easier. The subject matter of the arbitration must be contained in the clause. Who is the appointing body? Is it the parties that are appointing the arbitrators or the institution, such as maybe the Nigerian Chartered Institute of Arbitrators or the Settlement House, ADR Training Institute, or even maybe the Lagos Multi-Door Court House, or whichever institution? You have to make it clear in the arbitration clause that this is the appointing institution. And you also specify, is it one arbitrator you're appointing, or is it 2 or 3 arbitrators, or even 5? You have to specify that in your arbitration. Where will be the law that will guide this arbitration? That is the seat which other mentors have talked about. I know we know, but it should be part of the clause of the arbitration agreement. And then another thing that must be there is, what will be the rules that will guide the arbitration? What language? Is it going to be in French? Is it going to be in Swahili? Whatever language you want your arbitration to be, since it is party driven, you have to include it in that clause. So I want to encourage us to make sure that these things are there in the arbitration, and also to know that there are some badly drafted arbitration clauses that even though it is contained in the contract, it cannot be used. For instance, you provided for arbitration to be done, maybe in the event of any dispute between the parties, or regarding this contract or regarding this agreement, the parties shall finally decide their grievances by arbitration. And then you also put another clause that in case of litigation, they shall go to the Federal High Court of Cameroon. Now you have completely destroyed the arbitration clause. If you are saying that it is ADR that you will use for arbitration, then stick to it. But if you are bringing in litigation, then it is a bad arbitration clause, and it makes your arbitration difficult, because the court cannot use that either as arbitration clause or as any clause to show that the parties agree to be guided by ADR. And then moving forward, I also want to emphasize on what are the grounds for setting aside an award. An award that has gone through preliminary hearings, the parties have provided their point of claim, the other party have brought his point of defense, and the arbitrators have looked at the evidence. Maybe perhaps they use the Nigeria Chamber of Commerce rules to decide the arbitration. And at the end of the arbitration, what will be those considerations that will make the arbitration to be set aside? A lot of these have been discussed by the mentees, which I highly commend the mentees for their wonderful presentation. But I want us to look at it, especially in the light of the recent law of Nigeria, which is the Arbitration and Mediation Act. It is clearly saying that an arbitration should not ordinarily be set aside just like that, maybe for clerical errors or for typographical errors. There are things that can be corrected. But even those clerical errors and typographical errors should be corrected within 30 days. And then it is also saying that for an arbitration to be set aside now, before now, under the ACA, that is Arbitration and Conciliation Act of Nigeria, there is this big, huge ground that is used for setting aside, or as a ground for setting aside arbitration, and that is misconduct. But misconduct is an all-encompassing word. So now the Act have streamlined those considerations for which you will set aside an arbitration. And one of them is that the arbitration agreement must be valid, which is why I had to emphasize on the importance of arbitration agreement or arbitration clause. And one thing we must know is that this arbitration agreement might be inside the contract at the time of making the contract or drafting the contract, but it can also come later. But the important thing is that whatever it is, whether it was done along with the contract or it is an agreement that was done later, an arbitration agreement must be in writing. You cannot orally come to say that, oh, we had an agreement that we are going to arbitrate our dispute. You will not be accepted. So you must draft your arbitration agreement. And so if the agreement is not a good one, it can lead to setting aside your award. And then another thing is that parties must be given proper notice. So if perhaps you started an arbitration or you commenced an arbitration and the other party is not notified, and you went on even to the extent of getting an award, then your arbitration award can be set aside. So the party must be notified, very, very well notified, and the time must be adequate for the notification so that the party can have opportunity of airing his own side of grievance. And then another reason that can be used to set aside an award is where the award is on dispute that is not submitted to the arbitration. So where the dispute you have decided in the award is outside of the dispute that was submitted, it can be a ground for setting aside an award. And also where the award is beyond the scope of the dispute, it is also a ground for setting aside the award. Another ground is the composition of the tribunal. That is when it is not in accordance with the parties' agreement. For instance, in your arbitration agreement, you have stated that one arbitrator will decide your dispute. But at the end, when you were appointing arbitrators, you appointed 3 arbitrators. That could be a ground because it is not in tandem with the agreement that you had. And another ground that could lead to setting aside or challenging an arbitral award is when the composition is also not in accordance with the act. Maybe as parties did not agree to the composition, and then parties' composition is against the act. Maybe perhaps the act provided that you will have 1 sole arbitrator or 3 arbitrators, and you decided to have 4 arbitrators. When it comes to the issue of tie, it will be difficult because when you have like a tribunal of 3 arbitrators, 2 can go against 1. But when you have 4, sometimes it is difficult for you to have a kind of agreement of the larger number of the arbitrators. What if 2 are against 2? So in that circumstance, you will have a tie in the arbitral award. So if it is against what the act provided, it can also lead to setting aside the arbitral award. And another thing is where the award is against public policies. Some of the mentors have stated it. If it is against public policy of the particular seat, that is the law that is guiding the arbitration, then the arbitration award can be set aside on that ground of public policy. Then, if you are challenging an arbitral award, what will the court usually do? The court will usually go through the conditions or the circumstances that have been earmarked to be the reasons for setting aside an award and see if any one of them has actually been breached. Now, the court will either remit back the award to the tribunal to either correct a part of it if it is, if one of the conditions is, or one of the issues you raise has to do with a part of the arbitration, it can be corrected. It can be remitted back to be corrected. And then when the court realizes that it is something that cannot be corrected, then that award can be set aside on the basis of this ground. So for those of us who are in Nigeria, we could just look at Section 55 of the Arbitration and Mediation Act to check on these considerations. Now, I want to also look at a little bit at, and one of the mentors actually just finished talking about it, but I want to emphasize on the importance of ethics in arbitration. Now, as an arbitrator, your integrity is what will sell you. If you are known to be a person of your words, to be a person of your integrity, you are already having a selling point. That is what my co-mentor stated to be your brand. Your brand should be known as someone who is of integrity so that your award can also stand the test of integrity. You have to be an impartial arbitrator. You have to be independent. It means other considerations should not be the reason why you are giving your award. You are simply giving the award because that is what you believe, based on your conscience, should be the right thing to be done in giving the award. And another thing is that professional ethics or ethics in arbitration ensures that the arbitration is concluded fairly, and it also limits opportunity of challenging it. So if you are fair in your arbitration, which is one of the ethical considerations, it helps your arbitration award or your arbitral award not to be set aside. And another thing is that even in your appointment, when it comes to you being appointed as an arbitrator, if you know you cannot handle that arbitration, the scenario is not something you can handle, you are not professionally able to handle it, it will be unethical for you to accept that arbitration. So it is also good in your appointment to know that, can I do this? Am I professionally buoyant to do this arbitration? If you sincerely know that you can't do it, then please don't take the arbitration and then go and give an award, which can dent your arbitration practice later on. And another thing is that you must give parties equal treatment. One of the mentors have stated it that the way you treat party A is how you will treat party B. It's an ethical consideration in arbitration. Another thing is arbitration is confidential. Even though confidential is actually subjective, it is subject to applicability of some rules of some countries. So maybe the confidentiality rules in Nigeria might be different from the confidentiality rules in Cameroon. But confidential is the key word, and it teaches an arbitrator not to unnecessarily divulge information on his arbitration, unless if the parties have given you consent. But you are not to just go about telling people how you have arbitrated on this issue between Mr. A and Mr. B and you call their names. Confidentiality is very, very important, and it helps the parties to know or to have some kind of confidence in the arbitrator that he is taking their case very important. And then neutrality, you must be neutral in your decision. You must not favor unduly a party against the other. You must be neutral. And part of your ethical duties as an arbitrator is that you must not also accept gifts as an arbitrator. One of the mentors also spoke about it of you must not accept gifts and favors as an arbitrator. So an arbitrator shall not accept gifts or favors from any party that is interested in the dispute. So either the parties are clearly parties in the dispute or parties that are connected with parties in the dispute, you are not supposed to collect favors from them. You must be very, very clear about conflict of interest. That is where you must disclose. You must give disclosure. If you notice that perhaps you know some of those parties and you know that because of that knowledge, it can affect your judgment in one way or the other, you must disclose to the parties. And if the parties said, okay, we know you, this is what you know, and this is it, but we still want you to be the arbitrator, it's okay. But if you have not disclosed and the parties bring it up, then it's a dent on you as an arbitrator. And also on enforcement. Now, the law is that, especially for law in Nigeria, enforcement of arbitral award, is that an arbitral award can be enforced even if the award was not made in Nigeria. For as long as it is subject to the New York, the country is subject to the New York Convention. And now the act is not even specifically saying that it must be a country that is a signatory to the New York Convention. You can enforce an award that is made anywhere in the world in Nigeria. And you can also enforce Nigeria award as long as they are in compliance with the seat of the arbitration. So for now, I will want to stop. I know that time has already gone. I wouldn't want to keep our mentees or our mentors because we have said much and we have said a lot. And so as an arbitrator, you have opportunity of career as an arbitrator, which is the main career. For you to be either a sole arbitrator or to belong to an institution whereby you can be appointed as a member of a tribunal of an arbitrator. You can be a counsel as arbitrator. That is one of the career opportunities. And you can also be a secretary. You can start as a secretary or a registrar in an arbitral tribunal. While the arbitrator is the one who is dealing with the issues, you are taking records. You are keeping the records of all the parties' grievances, their points of claim, their pleadings, and everything. And you are in charge of making sure that the secretariat of the tribunal is functional and working well. That is also another career path you can have in arbitration. And you can also work with, just like we have been told, you can do a lot of volunteers, and from there you build on your career. So I do hope and I believe that our mentees are potential arbitrators. In fact, for me, with the rate at which you have done your presentations, you are very, very good. You are very, very good to go as far as arbitration career is concerned. And I do wish you well and hope that we will meet you on our way up. Thank you very much for this opportunity to JIIPC, and thank you for this opportunity to be a mentor even to the Settlement House Institute. Thank you very much.
Hey, we cannot thank you enough. That's beautiful. That's wonderful. Miss Pa has done wonderfully well. You can see that's the beauty. That's why I wanted it to be this way, because our mentors had the opportunity to make presentation on different aspects and topics as they felt led. And I believe that the mentees are really tapping from the anointing. Idris have done wonderfully well. Miss Pa has done well. Barato has done wonderfully well. This is it's as if I wish I had this opportunity, while coming up. But this is great. This is great. So having said so, remember that at the point of commencement, when there is a dispute, you can explore negotiation. And then after negotiation, if negotiation fails between the parties, you undertake assisted negotiation by a third party, which is called mediation. And where that fails, in an arbitral clause can actually capture this particular three layer of this thing. You can say you start with negotiation, after negotiation, mediation, and then after mediation, you can go for arbitration. It can be captured in your arbitral clause. So where you have taken all these steps and it fails, fine. But know that whether you have an arbitral clause in your agreement or not, you can arbitrate your matters. And aside, when you have an agreement without an arbitral clause, you can on your own. The parties can decide to develop an arbitral clause. They can do it and make it a separate document from the main agreement. And then even when the dispute arose, you can still decide to go for arbitration. So that is very, very important. And remember, arbitration clause must be in writing. When you say in writing, it must not necessarily be maybe on paper and pen and everybody sign. According to the new law, this writing we're talking about, AMA, Arbitration and Mediation Act 2023, is clearly written. It will be sufficient if it is in writing, whether in form of electronic evidence, maybe your WhatsApp chat, or in emails, or whatsoever that can show that there is an agreement to go for arbitration. That will suffice. But when you do a standard one, it will avoid the tendency of going for litigation eventually. So this is very, very important for us to take note of. Now, we have stated that we wanted the mentees to make a presentation that will cover areas like the various careers opportunities in arbitration. We have all mentioned that we're not going to go into that, but being an arbitrator will give you several opportunities. You're going to learn. You will learn how to become a judge. You will learn how to be an arbitral secretary. You will learn how to do case management. You know, these are all things that you can actually go into. You can be an expert witness, you know, you can be an international, you can testify as a lawyer on maybe a Nigerian law. You can be an expert, you know, in an arbitral process. You can be a counsel in arbitration. All of these things are career opportunities you can dive into. Now, arbitrability of dispute, we have said that it's not every dispute that can be resolved through arbitration, you know, and then the groups have done wonderfully well in this aspect, and I must commend them for that. They've identified you cannot have a matter that is contrary to, okay, for example, somebody says, please, can you get some gun for me, because we used to have some armed robbers around our area and I want to be dealing with them. They have been disturbing us. So you have an agreement and put an arbitral clause there. So eventually you given the money and then the person did not supply the guns, and then you say, oh, let's go for arbitration. It will not work, because that is contrary to public policy, is even against the law, is not is not allowed, is not permitted. You can only do contract, you can only go for arbitration in matters that are business inclined and where the parties have the absolute power to decide their own fate. Any other process that will business or arrangement that will involve somebody aside from the parties to take decisions, those things are not arbitrable. So you must take note of that. Arbitral clause and its significance is very, very important for you to have the arbitration clauses, as I've said, drafted. It can be engrafted into your agreement. It can be a separate agreement on its own. And in the event of dispute arising and there is none of these arbitral clause, you can still have recourse to it. You can decide to resolve your matter through arbitration. So when you have it, it saves you a lot of time, cost, disagreement, because where there is a dispute and someone proposes an arbitrator, where the other party feels that no, let's say the claimant proposed an arbitrator, there is every likelihood that the respondent is going to contest the arbitrator because a dispute has arisen and you do not have any formal agreement saying that you will go for arbitration where dispute arose. So that's one of the significance. Once you have that, it cuts, and then it can narrate, it can give qualification as to who should be appointed. 20 years post call, he must be a lawyer. 20 years post call, he must be a practicing arbitrator for so. He must be an expert in construction arbitration. He must have expertise in this and that and all of those things. You can set your qualification. Now, you know, in the previous law, the ACA, you know, the provision for arbitrators is 3 ordinarily, but the new law says that an arbitrator shall be 1, except an arbitral panel is properly constituted with 1 arbitrator, except where the parties say so, you know, says otherwise. Say we want 3 arbitrators. In that case, 2 of the parties will appoint 1, then the 2 of them is going to appoint the 3rd arbitrator. So take note of that. That's very, very important. So the significance of that is that it saves you a lot of time and cost and arguments and waste of resources, because people will begin to go and challenge the process. Remember, once there is an arbitral clause, it's irrevocable except by agreement of parties. So when you decide that, okay, I'm not interested, like one of our facilitators was saying, one of our mentees, Mr. Idris, where a party decides that it's not going to take part in the arbitration process, so it's not interested, all you need to do is to continue your process, keep serving him with his hearing notice, and then at the end of it, deliver an award, and that award is going to be valid and enforceable against the party. But you need to note that for the fact that a party or a respondent refuses to participate in the arbitration does not mean that automatically an award will be delivered against him. It is not like court of law where you say you have not taken any you have not participated, you have not filed every process, so they will just grant the prayers and requests of this thing. No, it is not like that. So you have to deliver your award based on merit. So that's one thing we need to understand, very, very important on arbitral clauses and agreements. Then we said arbitral award. You know, your award must be in writing, very important. It must state the place of the arbitration, the laws that was applicable, you know, your appointment, you know, it must state the brief facts of the matter, and then the award itself. You know, when you give the award, you must give reasons why you gave that award. It has to be stated, and it must be signed by the arbitrator. That award has to be signed by the arbitrator. You know, if the parties have their own counsel and representative where necessary, they should sign, but arbitrator's signature is very, very crucial. And once the award is done, because of confidentiality, you publish the award. And what I mean by publication of the award is to send it to the parties. You know, by that time, you must have received all the resources and the money, and you know, the agreed amount of money that was meant for it. So once you are paid and everything is okay, you publish the award by sending it to the respective parties, right? So you may have the assistance of a registrar or arbitral secretary, or some persons do it by themselves. So you need to take note of that. Now, you need to know the components or things that needs to be involved, that needs to be contained in an award, so that you will follow it and ensure that your award is watertight. A lawyer who is trained to look at things with an eagle eye will not begin to scrutinize your award and get a particular ground where you can go and set aside the award. Disclose where possible. You say, look at this person, he has been my business partner for a while. So person, she was my, in fact, I wanted to marry her before something happened. Disclose and then ask the parties whether, are you comfortable for me to continue as the arbitrator? If they say yes, you can continue, fine. But if they say no, we are not comfortable, then you kindly excuse them. It's very, very important. Take note of that. Then, you know, we ask the parties to draft an arbitral, an award, including key features. I've not seen people, they've told us some of the features, they didn't draft it for us. You draft something simple, name of the parties, you know, and then, you know, the name of the arbitrator, you know, the heading, this is a final award by sole arbitrator or whatsoever. This is the brief history of this thing, this is the decision, or this is the award by the arbitrator, and this is the reason why the award is given. Then the arbitrator will sign it. Very important. So when it now comes to the relevance of arbitral clause, you know, that have been clearly explained. Then we say discuss ethics in mediation. You know, ethics is important, even not for anything. Either practitioners survive based on the goodwill of their clients and based on recommendation from people. So when they get to know that your awards are always set aside, nobody will want to appoint you, because it is the parties that will first have to appoint you. Mr. Idris kept emphasizing that arbitration is party driven. The parties will decide the arbitrator, they will decide the venue, they will decide the fees, they will decide where, how the thing is going to be made. They are going to decide the law that is going to be applicable. They will decide the venue for the meeting. Everything, they are going to be the one to decide it, except the award itself, where you will do the needful. They are going to say, we are going to use only documents. No need for us to testify. They will say, oh, we want to testify and use documents as well. All these things are decided by the party. So arbitration is party driven. This is something that we need to take note. It's very, very crucial and very, very important. Ethics. Disclose be impartial, be neutral. These are things that are very, very important. And as much as possible, collect your money. Collect your money before you commence anything. Remember, in arbitration, parties share the cost. In mediation, parties share the cost. In ADR, parties share the fees into two. They pay half. Remember to collect your money before you come and start dragging your clients to court in order to recover your fee. You need to be very, very careful. If you are doing it pro bono, understandable, but if you want to collect your money, ensure that you collect your money before you get to that thing. So we have discussed seat of arbitration. That has to do with the laws applicable, the rules. The place of arbitration is the physical venue. So once you choose the law, you can decide to choose Nigerian law. Nigeria is the seat of arbitration, and you can be doing your sitting in London. That is place, location, not the law and the rules that is applicable. Remember. So that is that about that. Then conditions for challenging an arbitral award. It has been limited under the AMA, and our Baratu of Mentor has clearly explained that for us. Enforceability. When you want to enforce an award, I had an award that was delivered somewhere in Bauchi, and then we came to enforce it in Kaduna State. What you need to do is you file an application expertise, attach the certified true copy of the award itself, the processes that have been carried out in all those, the record of proceedings, of the arbitration. Those are the things that you're going to annex to your application for enforcement. So you have the original copies of the award. That's the certified true copies of the award. You attach it, attach the record of proceedings, and all of those things to your application expertise. And then you file it before the court, the High Court particularly. Court, according to the definition of the AMA, is either the Federal High Court or the State High Court. That is it. It does not include magistrate courts and all of those kind of things. So you need to take note of that. So when you want to enforce, you can have an award in one state and enforce it in another. You can have with the New York Convention and the Singapore Convention, all on ADR. You can have now international application and enforceability of awards for parties who are signatory to that convention, the Singapore Convention, all of those things. So you can now have that enforced. Having said so, I think we have covered all the these things. So, but it's important for you to take note that you are going to go into practicals. And when you are going into practicals, you are going to do mediation practicals. So you need to know the procedures and the processes. If it is possible for us to have a time where we will have a run over of the processes of what you need to do, I will discuss with Dennis, and then we'll get back to you so that we'll guide you through the processes, the things you need to do, in order to have a success. So if we need to have some little practice, we'll also discuss that and get back to you. But arbitration, very important. These are processes from the arbitral clause or your agreement. In the first place, you have the arbitral clause or a separate arbitration agreement written. That's where it starts from. Then when the dispute arose and you need to issue notice of arbitration. And according to the act, they said the time the notice of arbitration has been issued, that is when arbitration has commenced. So notice of arbitration is issued. The other person will either accept it or refuse it or propose other arbitrators. The notice of arbitration will also include the name of the proposed arbitrator you want to appoint, and the other party will also respond, oh, I've accepted, or no, I have other arbitrators I'm suggesting, so when you agree on that. But when you don't agree, they say according to the AMA, any appointing authority, be it some of the institutes we know, whether it is government attached or multi-door courthouse or private institutions that are operating, any of those arbitral institutions can can be an appointing authority. So you can say, let the president of so place appoint for us. Let the president of or the chairman or the executive director of Settlement House Area Training Institute appoint so person for us. These are things. So you need to go and learn the importance, as in the important ingredients of a very balanced arbitral clause. Very important. So once that is done, you issue the notice of arbitration, and parties agree and accept, and appointed an arbitrator. He calls for a preliminary meeting. In the preliminary meeting, you are going to list, at least you need to study this and know them. There are items that need to be discussed, including arbitrator, the registrar, including the place, the rules, the venue, the fees, and very other important, how the procedure is going to be, the timing for filing of processes. All these things are going to be discussed in the arbitral, the preliminary meeting. So after the conclusion of the preliminary meeting, the arbitrator or the arbitral tribunal is going to issue what is called order of direction. So you are going to issue the order of direction containing all that has been agreed upon. Then you fix a date for hearing based on what you have agreed upon. Then the hearing is as normal as the things that happen in court. One party presents his own case. If he has a witness, he calls the witness and he has opportunity to cross-examine the witness. And after he finishes and closes, the other party also starts his own, call his witness, and the witness are also cross-examined after they testify. And when that is done, at the close of it, you may decide to say you want to address the court orally or in writing. And once that is done, after you conclude everything, the arbitrator now has his own time to go and write the award. So if you're able to follow these processes and the procedures, that is done. One of our mentors, Mispa, was mentioning about, in case maybe there are things that has to be that are perishable, and you need maybe an order, from the arbitrator, maybe an emergency arbitrator, to be able to arrest the situation before it gets worse. All these things are also considered. So please study the guideline, the arbitration, the mediation arbitration scenario we sent to you is one scenario, but you are going to use it for both mediation and arbitration. Those who want to have maybe a session, maybe some kind of rundown session, can also indicate, so that we can see what we can do. Let it be that you partake in the simulation or the practical sessions during our presentation, and then we hope that it's going to be wonderful. So having said so, thank you very much, Dennis. I think we have covered what we need to cover. So please, over to you.
Thank you so much, Mr. Nyancham, and thank you so much to all our mentors that were able to give us a thorough rundown and breakdown of today's topic on arbitration and career opportunities in arbitration. We are far short on our time, but we'll still be taking questions. So please, if our mentees have questions, please, we are taking questions right about now. We'll be taking live questions first. So our mentees can throw in questions.
Okay, so Dennis, 1
yes, sir.
minute. Now, the mentees, if you are listening to me, we are very sorry for overshooting the time, but you should be rest assured that it is all for your interest, because we could have just say, oh, it is time, let us shift it, but some of the things you are supposed to learn or get, you will actually lose it. And when you want to attend a training where some of these things are going to be discussed, it's going to be a very huge amount of money that you'll be paying, So we are doing this. It's our own way of giving back to the society, and this is free. So please, I will crave your indulgence to be patient, and then take advantage of the situation. Take advantage to ask your questions. We have the mentees who are here, and they are available to answer your questions, so that when you call for a consultation session, You're going to pay a lot of money,
Guys,
so
stop
please take
touching that
advantage of
law.
it. Thank you.
Thank you so much, sir, for that. For helping us encourage our mentees. So please, if there are questions, please, we'll be taking questions right about now. I think Victoria, do you have a question you want to ask?
Okay. Nami.
Yes, Victoria, we can hear you. Please go ahead and ask your question.
No, I don't have a question.
Victoria?
I do not have a question.
Oh, okay, okay. You were unmuted, so I thought you had a question. So please, we are taking questions. Okay, during the while the mentees submitted their presentations, they also sent in a few
There is a
questions.
question. There's a question on the chat.
Yes,
Oh,
I was the one who posted it. The mentees during their presentation they sent in a few questions. So when they were compiling their presentation, they sent in a few questions, and I think quite a number of them, right, have been addressed by our mentors. But I think there's still a few we can still take here. For instance, okay, question 3 here says, "What are the benefits and challenges of a career in arbitration?" Um, is we'll just like to give it like an open forum to our mentors to jump on the question. What From our mentors, what are the benefits and challenges you could think a career in we can a person or a mentee who is an enthusiast in arbitration? What are some of the benefits and the challenges that person can encounter while pursuing a career in arbitration?
well, for me, quickly, let me just say something on these benefits. The benefits are enormous. Of course, like so many of us have said, somehow in passing, you get paid very well when you do arbitration. Your payment is given even before you conclude the arbitration. So you are certain that when you are conducting any arbitration, you are going to get paid for it. But for the challenges are that you hardly get this arbitration or appointed as an arbitrator without you being known. And as it is now, perhaps maybe getting yourself to become an arbitrator or to be given an arbitration case is not something that comes easy. So it's a challenge, which is why you have to put yourself forward. You have to make yourself, your brand known so that people can recommend you, people can pick you up. And these are some of the challenges which you have to work on if you have decided to become an arbitrator. But for the benefits, you always get paid for whatever job you do as an arbitrator because it's a profession. Thank you.
Thank you so much, Ms. Baratu, for helping us with that answer to that question. I'm sure our mentees are listening and they are taking notes of everything that is being said. So the next question we have here, and
Um,
we are still encouraging our mentees to still ask questions. Please, you can send in your questions into the chat box.
okay,
Okay.
so Mr. Idris is here. Let me ask a question um, so that others can also ask. Now, sir, particularly to you, sir. um, if you have a situation where you a claimant they have an they have parties have an arbitral clause in their agreement, and they said in the event of dispute they will try to settle maybe via negotiation, and if it fails they will resort to arbitration. Then where the dispute arose, one of the party wrote to the other party that okay, is calling for a meeting for them to discuss and see how they can resolve the matter, and the party did not respond, although the party received the notice. So after a while, the party now went ahead and said, having refused to acknowledge and then did not say anything concerning the settlement, now went ahead and issued notice of arbitration and suggested an arbitrator and said that, okay, after the period of 7 days, I'm expecting your response to this notice, including what you have to say about the proposed arbitrator. And if after 7 days you refuse to respond, it will be deemed that you have accepted the arbitrator. Even at that, the arbitrator, the other party received the process and the notice and still didn't say anything. So after the notice, a notice of preliminary meeting was issued again to the other party by the arbitrator, the proposed arbitrator, calling for a meeting, and the party receives it, did not say anything again. But on the day that the preliminary meeting is going to hold, the lawyer to the respondent now wrote a letter to the lawyer to the claimant, stating that they have reported some of the issues and the matter to the EFCC, and then their participation in arbitration is going to be prejudicial to the process, so they cannot participate in the arbitral process. So when you have situations like this, how do you go about it?
Very tough question, Nanchang. Are you sure this is not a case you're handling? But I can send my bill, right? I know you already know the answer. But just for the mentees, these are actually real life situation questions. And the scenario Mr. Nanchang has painted are things you probably see in real life practice. First, let me talk about the agreements. They're quite most standard clauses in most arbitration agreements always have what is known as the layered dispute resolution clause. That is where parties are supposed to, first of all, try for some form of negotiation before invoking or trying to go into arbitration. In fact, there is something known, Mr. Nanchang will tell you, known as ABMED, where that is arbitration and mediation. So you first of all try arbitration. If after the arbitration doesn't works, you now go for mediation. Or if first of all try mediation, and if mediation fails, you go for arbitration. So those are just some of the forms. Now to go into the main question, which is, as far as I'm concerned, in this question, an arbitration has been effectively commenced. A notice of arbitration has been issued. The party on the other side has notification about the arbitration that has commenced. So in this particular situation, can the fact that a criminal offense has been reported to the EFCC means that there has been a revocation of the arbitration agreement between the parties? My categorical answer to that is a no. Criminal offenses, and in fact, there is a plethora of authorities on this issue. Criminal offenses and criminal proceedings and civil proceedings can go on simultaneously, if insofar as what was reported as a crime does not necessarily affect the civil proceedings that has been commenced. So if there's an arbitration clause and it has been effectively evoked and the party on the other side has commenced action on notice to the other party, I do not see what is stopping them by you coming to say that you reported the matter to the EFCC and as such you cannot submit yourself to arbitration. I do not think that would be sufficient. I think rather that you need to further show that the report of the matter to the EFCC will materially affect the arbitration proceedings. And that would be, and you have to go to the arbitration to argue that point. In fact, under what heading would you now bring that? Anyway, thinking about it openly now is most likely going to say that, okay, maybe challenge the jurisdiction of the arbitration panel by saying that the agreement in itself was an illegality. But even if in the course of the operation of the agreement, an offense was committed, and the issues that have been brought under that agreement does not materially affect the arbitration process, I would say that the arbitration process would go on, and the report of the matter to the EFCC would not materially distort or affect the jurisdiction of the arbitration panel. The issues as relates to the jurisdiction of an arbitration panel has been clearly spelled out by most of the mentors. Number one, the agreement. What does the agreement say? The arbitration agreement say? Well, how do you evoke it? If, like one of the mentees said, that the agreement in itself is not is pathologically defective, then it will become extremely difficult for us for those arbitration to be successfully evoked. So, in the simple answer to your question, insofar as it does not affect the jurisdiction of the arbitration panel that has been constituted, I believe that the arbitration can go on. And it will also now be, my answer will also now be subject to deeper facts that may have been, that may be provided. So it's, my straight answer is the arbitration can go on. The arbitration can go on because the criminal offense or whatever that has been reported to the EFCC is not one of the instances under which the jurisdiction of an arbitration panel can be challenged. Thank you.
Okay, so thank you, sir. You know, the AMA has clearly stated that in fact, where there are ongoing matters in court, they can be put on hold, and parties can proceed with arbitration until an award is given. But I think we have not contemplated where the matter is reported either to the police or to the EFCC in these circumstances. So maybe this is something that maybe eventually we will get to address. Then we have a question here. Is arbitration solely for commercial related disputes? I think that one, without waste of time, I think majorly is yes. Is for dispute that the parties have the power. You know, it some extent, you know, is within their ability to either compromise or to decide and settle. Anything that is requires maybe some other authorities aside from the parties, I don't think that is good for arbitration. So our other mentors can add to that. And the second question is, as a certified arbitrator, can I be consulted to arbitrate on a matter as a sole arbitrator without being part of any larger body like their comments to these questions, please? So, sir, you can go ahead, or any other person, mentor, Baratu, anybody, you can just comment on that.
Okay, let me just quickly chip in. Is arbitration solely for commercial related disputes? Yes, and yes. Basically, it's party driven, but I've also seen instances where parties now submit certain disputes to arbitration. The key word here is that parties have agreed, and it is only when they have agreed that the jurisdiction of an arbitral panel is well constituted. The second question is, can I, as a chartered arbitrator, as a certified, can I be consulted to arbitrate on a matter as a sole without being part of any larger body like a? Yes. There's something called ad hoc arbitration, which anybody can be appointed. Anybody can decide to appoint even a layman for you to become an arbitrator. On most of the certifying both institutes that I know, you just have to go through their processes of admittance. I'm sure Nanchan can also help in this, since Shati is also one of the emerging bodies particularly in northern Nigeria now. So you don't have to be a lawyer to become an arbitrator. Once you go through the process of getting certified within the institutes, you can do that. And even if you're a lawyer, or even if you have some form of stance, and a particular party comes to you and says, I want to appoint you as an arbitrator, and you accept, is the person. The snag to it is that if you do not have the experience, if you do not have the teachings and the trainings, the law you may not be able to effectively determine. You could see that all three mentors that have participated in this program have listed a whole lot of procedures, do's and don'ts, appointments, how do you enforce, how do you challenge jurisdiction, you need some form of training to learn that. So while the answer to your question is yes, anybody can be appointed, I would strongly advise that you get some form of certification. And I think it was MISPA that made a very solid point. And that was the fact that you need some form of training, no doubt. In fact, that's why I love the work that Shati is doing, because you see that essentially, even within the legal profession, we have so many people that do not understand or appreciate what arbitration is. And so when when matters get referred to arbitration, one of our sticking points with the advancement of all forms of alternate dispute resolution mechanisms are the fact that even the principal actors and the principal stakeholders that we should propagate these things do not have the necessary trainings, do not have the necessary exposures. So you as mentees that are coming up, I wish there was a way that we could include ADR right from the universities to law school, so that people, as they come out, are already sensitized about it. MISPA also made mention of something that was going on in Kigali, and I was in Rwanda. I was very piqued by it, which is the fact that the courts over there are now using ADR to decongest their dockets. It is critical. There's most jurisdictions in Nigeria, courts, they are doing that. I was in the Federal High Court in Lagos. The man had 25 cases in his that he was going to be hearing on that day. By the time he got to 1, 2 o'clock, he was already tired. So if we could actually get, not only from our high courts, also on our appellate courts, if we could get some form of ADR to take over this entire, to reduce these things, it will really help. And the only way we can get this done is by what we are doing now. And again, I must commend the Shati and the JIIPCC for their commendable efforts. Thank you.
Thank you very much, sir. So just briefly on that, you see, how do I become certified? I've told you, Mr. Idris, I know you maybe an idea of fees for registration for some of the trainings. I know CI app, they pay sometimes in dollars. Do you have idea, Mr. Idris, how much an associate training is for CI app for associates?
So, what I can do is so that we have accurate information, is to trying to check it up. I received a mail on them on their.
As you do that,
yes, on their
I know that. Yes, as you do that, training on Nigerian Institute of Chartered Arbitrators, the associate training is about 200,000 naira. I don't know if they are going to increase it for this year. Membership training is about 300,000 naira, thereabout. Then fellowship training, I think maybe about 500 or 700, thereabout. I'm not too certain about the fellowship training, but for the associate and the membership. So for CIF, I think they pay in dollars or in I don't know whether euro. There are parts you pay maybe you pay some in naira and then some in dollars or something like that. So Mr. Idris is trying to find out that. Meanwhile, Settlement Area Training Institute is also working on a package. We do trainings in ADR generally, mediation and arbitration. We have not commenced our arbitration training, but we will commence it very soon, maybe before the middle of the year. So, but all mentees in this platform, we are already talking. We have not concluded on how we can get you a very discounted, maybe rate because of your participation. If you participate well from the beginning to the end, and we see your performance, you graduated, you'll be able to have maybe a discounted rate for any of the trainings that maybe the institute is going to. So when we work out modalities and we're able to conclude that with JIIPCC, we will be able to see how our mentees will take advantage of it. Are you done?
Yes, I'm dropping the link in the search now. So the link will tell you, it will tell you how much that each of those courses will cost. But there's a route. There's a route to doing this. Except you have some form of experience, it might be very difficult for you. The normal way to start, especially for the Chartered Institute of for the Chartered Institute of Arbitrators UK, is for you to get started with what is known as the associate level. Mispa also mentioned this, I think she did, that there are 4 stages on this,
yes.
I need for the Chartered
Institute. The link is on the chat group.
The link is on the app now. This is for the Chartered Institute of Arbitration Nigeria, their training program as at this year. I didn't want to give anything without ensuring that it is an up-to-date information. So you could go to that link and click on any of those. It will give you the total amount that you're supposed to pay. For instance, Introduction to Domestic Arbitration costs is about 80,000 naira. And then there's the pounds. The assessment fee is for 72 pounds. These are things that I'm sure as you try to get into it, you will be able to see how it works. The other part, which I just wanted to make a comment on, because I can see it's almost close to 9, is the fact that there was a question as to the benefits and challenges of becoming an arbitrator. This, I believe, is one of the challenges. And this is what discourages even a lot of lawyers from getting into it. The cost of the trainings. Nanchang would know that he has tried a couple of times to even give out free trainings that people do not even attend. And then, so this is actually a challenge. But one of the things I would like to tell you is that you see what we are doing now, it's also a form of networking and marketing of our services. And as you get involved in all of these things, I've taken note of most of the people that have attended. In a way, you just keep those names in your head. One day something comes up, you're like, oh, I attended, and you approach either myself, Nanchang, or any of the mentors that were on this platform. I attended and you were one of the mentors. I would love to get, of course, why won't we oblige you with some form of assistance if we can? So I seriously encourage you to be more active in this. And there's a huge opportunity. There are huge opportunities out there. It's just for you to be able to figure them out and bring them out.
Thank you. Thank you. Our time is fast spent. I can see Gloria's hand up. You intend to ask a question or something?
Yes, please.
Go ahead.
Yes.
Quickly.
Thank you. Thank you, please. First of all, I want to thank Settlement House Institute for this invaluable opportunity. We will never take it for granted, please. first, quickly to my question, please, we've been told severally to put ourselves out there, okay, and put ourselves out there, probably keep posting content on our social media platforms concerning Nigeria and what all we know. And now, assuming we just keep on doing that, probably on our WhatsApp status and all of that, and then, educating people probably on ADR and other forms of alternative disputes instead of going to court, and then someone or persons begin to approach you, and we are yet in a mentorship level. Please, how do we relate? How do we now answer such a person, and what do we do? Because as far as now is concerned, we do not know ABC and this. Okay, so please, that's a personal question. I wouldn't know. Please, can you help us on that? Yeah, because I know people will approach us as we keep posting that. Because personally, I'm doing it. From what we've done here, I will also post it out there now. I know persons might begin to approach and ask questions. Please, how do we help them? Thank you, please.
Mr. Idris, please, quickly, if you can, contribute to this so that we'll close. So sorry for keeping you guys till now. Mr. Idris, would you like to attempt the question? Would you like to attempt the question? She said Yes.
Oh,
can you?
Oh, sorry about that. I had another call that came on the phone. Yeah, sure. Gloria, that is why you're attending this. So when you see those kind of questions and you feel that you cannot answer them, just refer to any of the people that you've seen here. I think if you reach out to Mr. Nanchang or myself and you say you have this question that has been asked and you just want some further elucidation on it, or what do you tell the person? I'm sure if we're not too busy, I'm sure we'll be able to help you out, but particularly if it is something that could easily be done. That is where you're not asking us to go and give advice that we ought to be paid for. So please feel free, and that's why you're attending this kind of things, for you to reach out to people, especially mentors, for them to be able to help you in such situations. And another thing is that I don't think any of these mentors are also they're also, what's it called? The repository of knowledge alone. Most of any of these facts can be found online. And if you say, one of the things I like to do with people I mentor is for them to show me their workings. And what do I mean by that? That they've already done some of the homework and they're just coming out to me to clarify. So for instance, somebody asks you a question on arbitration, and you say, and you've done your research and you just come to either Nanchang or myself or Baratu, and you say, hey, look, I have had this question and this is what I found out. So that I just want to confirm that it is the accurate position. Of course, that way, all we have to do is look at it for you and we say, yes, shoot. And then, so please do not propagate, tell people, bring it out, put yourself out as being a learner or somebody that is interested in ADR. If they ask you questions, I'm sure you can find answers to those questions. And if you can't, just reach out to any one of us. I don't think that would be a snag to you learning. And just one last point, and which was repeated by Nanchang Mispa. I wish I had this opportunity when I was trying to build a career. It's so true. A lot of times, if you ask any of the people that are now gradually becoming the voices of this, is that most times we're self-built. We're people that just took an interest in those things and went all out to get those knowledge. So for you to be having this, it's a great opportunity which you should use. And secondly, again, thank the people that also are facilitating this for you. So in a nutshell, that's my answer to the question. Sorry, I have to leave now.
All right, thank you. Thank you very much for that wonderful session. I believe that if you have further questions, drop them on the chat group, on the WhatsApp group, reach out to me, reach out to the mentors, reach out to Dennis. Your questions will certainly be answered. Dennis, sorry we stayed up to this time. Mentees, bear with us for your interest.
Thank you very much, sir. It's a welcome. The timing itself is not too bad, sir. We still thank you, all our mentors, for still helping us run through today's class. It has been a wonderful session, very interactive. Mr. Idris, Miss Barato, Miss Mispa, you yourself, sir, you people have done so well in helping us, give us detailed as explanation into what arbitration is and the career opportunities that are available in them. And I want to say a big thank you on behalf of our mentees. I also want our mentees to just go ahead and react in the comment section, show their emojis saying that they are really grateful and thankful to our mentors for helping us through. If, like our mentor said, if we were to pay, right, they gave us some courses that if we were to break down through the amounts that you are supposed to pay to get some of this knowledge in themselves, right, you it's a lot in itself. So this is a good starting point for all our mentees, right? We appreciate our mentors for all they do. Thank you very much. And with this, we've come to the end of today's session, right? We look forward to having both our mentors and our mentees in our next session. For this particular area class, we have two more, I think two more sessions, except otherwise, we fix other sessions for the practicals, which will be communicated to the mentees. Thank you so much to everyone, and I wish everyone a lovely night rest. Good night, everyone.
Nice, everyone.
Good
Thank
night.
you.
Good night.